Hello friends, today's video is purely educational purpose. I would like to say entertainment as well, but I don't think there'll be too much of that because I'm just not funny. All right, the topic today is Privacy Act 1988, Section 94H. Obviously, Privacy Act 1988 is a large act dealing with our privacy. It happens to be apparently above current public health orders, and the Section 94H sounds like it would have been added since the latest pandemic. So without further ado, we'll go into that act and try and understand it. It's not actually very long. Requiring the use of COVID Safe. A person commits an offense if the person requires another person to download COVID Safe to a communication device or have COVID Safe in operation on a communication device or consent to uploading COVID app data from communication device to a national COVID safe data store. Penalty is imprisonment for 5 years or 300 penalty units, which currently I think equates to $63,000. The second point of that same act is a person commits an offense if the person refuses to enter into or continue a contract of arrangement with another person, including a contract of employment, or takes adverse action within the meaning of the Fair Work Act 2009 against another person, or refuses to allow another person to enter premises that are otherwise accessible to the public, or premises that the other person has a right to enter, or refuses to allow another person to participate in an activity, or refuses to receive goods or services from another person, or insists on providing less monetary consideration for the goods, services, or refuses to provide goods or services to another person, or insists on receiving more monetary consideration for the goods or services on the grounds that include the ground that the other person has not downloaded COVID Safe to a communication device or does not have COVID Safe in operation on a communication device or has not consented to uploading COVID app data from a communication device to the National COVID Safe Data Store. Imprisonment for 5 years or 300 penalty units or both. To avoid doubt, subsection 2 is a workplace law for the purpose of the Fair Work Act 2009 and the benefit that the other person derives because of an obligation of the person under subsection 2 is a workplace right within the meaning of part 3-1 of the Act. All right, there was a lot of person must do this, person must not do that in this Act. However, summarizing it, what it seems is that this Australian Privacy Act 1988, Section 94H, is telling us the following. No one can ask you to provide medical information, for example, an employer or anyone asking you if you are vaccinated. You are not allowed to, they are not allowed to know anything about your personal health status. It kind of makes sense. No one can track your movement, for example, signing into a cafe or restaurant, pub, etc., being required to have a tracking app. You cannot be refused entry to a business open to public. You cannot be refused entry to a business that is otherwise open to public. Breaches, like I said, are $63,000 or 5 years imprisonment. Looking back at the Privacy Act 1988, Section 94H, the actual original document as we read it is that the person commits an offense if the person refuses to allow another person to enter premises that are otherwise accessible to the public or premises that the other person has the right to enter. I will let you translate that yourself to your daily life and what you're being asked to do, and whether it's lawful, legal, or not. This was an educational video only. There should be more of those coming as I'm looking into these things. That's my current interest. We are keeping an eye on the markets, and I've got some kind of valuable, I would like to think, information and insight, which I'm going to share with you in one of the future videos coming up, actually not long, so soon. With that, I'll close this video. Take care, and we'll speak again soon.